Hi everyone, and welcome to our webinar, The ABCs of Recruiting Compliance. My name is Angela Lee, and I'm on the marketing team here at Jobvite. First, you'll notice that all lines have been muted to avoid background noise. However, we would still love to have your questions. So if you want to use the chat box at the bottom of the Ready Talk panel, we'll be monitoring it throughout the presentation and saving your questions until the end. Additionally, all attendees will receive SHRM credits by attending this webinar. We'll be sure to send out the code for this at the end of the session as well. Now on to the webinar. I'll start off first by just running through a quick agenda. First, we'll be introducing our speakers, Chad and Izzy, and then we'll talk about how to ensure you're a compliant recruiter. We'll move on to discussing rules and regulations around compliance, and then finally finish up with a Q&A. Now I would love to introduce our speakers, Chad and Izzy, and I'll turn it over to you both to introduce yourselves.
Wonderful. Thank you, Angela, and thank you everyone for taking some time to join us on this webinar today. My name is Chad Raudebush, and I am the Recruitment Marketing Manager and a recruiter here at Jobvite. I've been doing this now for a little over 10 years. Spent early part of my career in recruitment marketing only, and then transitioned over to purely recruiting. And now with Jobvite, I get to mix both of those worlds. I'm an avid sports lover. Anything sports, you've got my full attention. So I love sports analogies. I love competition. I think that's what makes me a good recruiter, is the competitive edge. So that's a little bit about me, and over to Izzy.
Thanks, Chad. I'm Elizabeth McLean, but I go by Izzy, and I'm the General Counsel for Good Hire, and that's an employment background screening company located out in San Francisco. I've been at Good Hire for about 4 years and lead the legal and compliance departments there and help keep our customers out of compliance troubles in the regulatory landscape. I'm a huge geek, and I'm not afraid to admit it. I love sci-fi shows, especially Ray Bradbury Theater and Twilight Zone. I love bird watching, and some do consider me a subject matter expert in background screening compliance. I'm not sure I go that far, but I certainly love talking about it, and I think we have a good amount to discuss today, so I'm excited to get started and share some information with you all. Thanks.
Great. Thanks, Chad and Izzy. And now I'll turn it over to Chad to talk about how to ensure you're a compliant recruiter. Chad, take it away.
Wonderful. Thank you very much. Yeah, so I'm going to take the next few minutes and just discuss a couple of things, some tips and tricks, some best practices, some recommendations to make sure that as a recruiter that you are holding up your end of the bargain to make sure that you stay compliant. So I definitely wanted to start off and share some statistics with you. The candidates are really ruling and have a lot of control in the job market, with the unemployment rate being as low as it is. Things that we can do as recruiters to not only stay compliant, but to create a good candidate experience. Thinking about your application process, and is it compliant, and are you taking too much advantage of what the application process looks like that might force some abandonment? Really taking some time to look at that and make sure that it's not too cumbersome. That's going to deter candidates from continuing through that application process, because word of mouth is so strong. Social media is so prevalent in our world, and the more candidates have a negative experience, they're going to share those on social media. Not only are they going to share those, and it's going to start a trickle-down effect, but they're also not probably going to consider your company for future opportunities. So just taking things into consideration on the front end around where we are in the marketplace when it comes to being a candidate, being a recruiter, and the very small pools that we have to work with the unemployment rate being as low as it is. Thank you, Angela. So some things that I want to talk about today. I'm going to talk about several key factors that come into your role as a recruiter, staying compliant, eliminating bias. And so when you are screening or interviewing a candidate, you want to create a very positive candidate experience, but at the same time, especially if you are an OFCCP or government contracting company, you want to ensure that compliance. So some takeaways from the statistics that we shared on the previous slide, you want to create that that comfortability with a candidate and making sure that their involvement in the process is positive during the screening, and it can make or break if a candidate ultimately decides to join your company. So you can be creative to create some positive experiences while also ensuring that you do stay compliant. With candidates having that upper hand in today's market, that positive experience that you can create as a recruiter and further on in the process with additional interviews can lead to a great hire, can lead to potential leads from that hire. And even if you don't move forward with an offer for a candidate, if they have a positive experience, they're going to possibly send you some positive leads because they had such a good info. Just always keeping in mind throughout my slides and my talk track today that there are ways to maintain that positive experience while staying compliant as a recruiter. Next slide. Thank you. So what can we do to kind of create that experience? Some things that I definitely recommend are making it about the candidate. Allow them to do most of the talking. Allowing them to do most of the talking is going to help uncover some of their background, which is going to allow you to ask appropriate questions as it relates directly to your company-specific compliance guidelines. So I know as recruiters, I'm following that category. I'm a talker. So try your best to allow the candidate to elaborate, because there is where a lot of your questions are going to be answered. Okay. If it gets towards the end of the interview, hold those specific compliance questions until the end. A couple of reasons why: you might not be moving forward with that candidate. Therefore, those questions might not be relevant. If you feel good about moving forward with that candidate, you need to ask some more detailed questions to assure that you are compliant. I like to and advise everyone to lead with something along the lines of, really quickly, Mr. and Mrs. Candidate, I want to visit some HR-related items before we move forward in the process. This, right out the gate, allows them to understand the next line of questioning and puts you in a position that, again, you're creating that positive experience, but asking it in an appropriate way. And finally, be very specific. The more confident that you sound, the more professional your line of questioning, it's going to come off polished. It's going to, again, attribute to that positive candidate experience, thus ensuring that they feel good about their first interaction with your company. So a couple of questions, and these are, again, very specific that we ask here at Jobvite and that I definitely recommend are: will you now or in the future require sponsorship? Or are you legally eligible to work in the U.S.? Having these questions written down in front of you to ask a candidate is very important, as the wording can be tricky sometimes. You want to make sure that you are abiding by those guidelines. So thinking about pre-screening questions as it relates to compliancy, you need to think about these questions and are they compliant? A couple of scenarios that I definitely wanted to share with you guys today are, when you are reviewing a resume or an application, if things like the address that the candidate has entered, or their work history, if they've listed the location, the college that they've attended, if those things aren't lining up with any pre-screening questions that you have asked that candidate to answer, email them or give them a call, especially if they have really relevant experience and you want to talk to them. However, their pre-screening questions, auto-rejected them or excluded them from moving forward due to your process. Take the extra couple of minutes to review those and just make sure that things are aligned, because we're all human, and sometimes data entry, we might select the wrong drop-down, and definitely want to take some time as a recruiter to review those. Scenario 2 is preventing bias. Some things that I've done in the past that have worked really well, especially if you are a government contractor and you do have OFCCP guidelines that you need to abide by. Try not looking at a candidate's name or LinkedIn profile picture. If you do have a recruiter license, you can work with your representative to have profile pictures removed when you are logged into that recruiter seat. This will definitely help eliminate bias. As humans, we all have them. We have implicit biases, and we can't really control them. One tool that I have always relied on in my career is utilizing Harvard University. They put out so many quizzes. If you just Google Harvard and implicit bias, you're going to immediately find some tests that you can take, some quizzes that do nothing more than purely help you identify the biases that you do have as a human. Again, we all have them, but doing some little things like eliminating the pictures, the profile pictures on LinkedIn, identifying what biases we do have as individuals will really help you to eliminate those, minimize those at best, and again, that's going to help you with creating some more restriction in your compliance. And number 3 is utilizing your ATS for pre-screening questions. Again, some of those examples I gave around, are you legally eligible to work in the U.S.? Do you currently reside in the U.S.? You can ask those in the application process. They're quick and easy yes/no questions. This is going to help save time. It's going to help narrow your candidate pool. And more importantly, going back to that positive candidate experience, if a candidate is ineligible to be considered for an opportunity within your company, you can create specific messaging that's going to, while you're not moving forward with that candidate, you can send them a nice detailed email that's going to keep that experience positive, even though they're getting that rejection email. Oh, this one is something that has been coming up over the last, I feel like 18 months. When it comes to state-specific compensation, know the laws and regulations in which you're hiring. So many of us live in a remote-based working world today that many states have implemented. Actually, there's about 13 states that have implemented laws and regulations against asking for compensation information. So know which states enforce these. Better yet, and a huge tip that I want you to walk away with, and something that I practice, is just treating every state that the candidate might reside in the same. Just completely avoid asking for information. I like to ask the question of, I'd like to gain an understanding around a salary range that you'd be looking for in a new opportunity. So what this does is, you're not asking for their current compensation or salary. You're not asking them to provide any details or information. While some states still allow this, I think it's a best practice as this kind of catches on throughout our country, to just treat every state the same and assume that they all have regulations against obtaining that compensation information during an interview or a phone screen. A couple of other things to take into consideration. Are you a government contractor? Do you have specific OFCCP guidelines that you must abide by? Are you up to date on the Equal Employment Opportunity Commission? These are just little things, and so many times there are changes that are made that us as recruiters can take ownership of that, and just being up to speed on what those rules and regulations are, and what are your company specific rules and regulations, and just knowing and being educated and doing some research and being cognizant on the front end of what those are, so that you can avoid questions that seem harmless during a recruiter screen. There's so many questions that could violate either of these, and sometimes we don't really take them into consideration. We as recruiters want to create that positive experience. We want candidates to feel comfortable. We want them to feel at ease when they're talking to us. It really opens up the conversation. But too many times that can lead us to asking questions about maybe the college they attended, where they live or grew up, about their family. Again, wanting to make them feel comfortable. This toes a very fine line of going down a rabbit hole you do not want to go down. You have control of the conversation. Make sure that you are asking specific questions as it relates to their skills, to their experience, and the job specific that they are being considered. If a candidate does begin to share information that you've got them to that, I'm very comfortable with you, Mr. Recruiter, and they start talking about family or background or the college that they attended, you need to redirect that conversation quickly back to the relevancy of the conversation around their skills, experiences, and the job. No candidate is going to take offense if you're like, I really appreciate you sharing that, but let's get back on track, and I have a few more questions before we get to the end of our time today. So just take that into consideration, that while we want candidates to feel comfortable, we need to own and control the conversation. This one is really important, especially if you are a government contractor and abiding by specific rules and regulations. You need to track all communications. I recommend real time. I know sometimes that's not possible, but track all calls, all texts, emails within your ATS or any system that you are using. Because in the event of an audit, having those breadcrumbs documented for all candidate interactions is really crucial. If a phone call or text conversation takes place, be sure to enter the context of that conversation in the candidate profile real time or at least the same day. That timestamp, that date that is entered could play a factor down the road if an audit does occur. So really taking the time to make sure that you do track communications with all candidates in some way, shape, or fashion. If your ATS doesn't offer that, definitely have some sort of a system in place that to make sure that that is something that you're doing. Another one is revisit some of those pre-screening questions and the voluntary identification questions that you are asking. Don't have to revisit them very often, but again, going back to making sure that you're staying up to date on rules, regulations, compliance guidelines, and revisiting those questions, whether that's every couple of months, every quarter, and just reading those verbatim and making sure that the verbiage is appropriate and that you're compiling questions that are going to capture the information that you are requiring. And then finally, work with your vendors and partners. There's so many options out there now that will help provide you with tools, systems, to track questions and make sure that you're staying compliant. So definitely, some are free, some are included in the contracts that you might have, some might be an additional cost, but definitely leverage those partnerships, leverage your ATS or recruiting system to make sure you're documenting those and see what other options that you have out there to keep yourself compliant. A couple of minutes now to talk about, kind of creating a diverse audience. Where are your jobs being posted? Outside of your career site, are you manually posting to other job boards? Do you have a list of job board sites that are scraping your career site? And where is the exposure happening? So really getting a good understanding of where your jobs are being posted is really important. There's so many job boards out there that just scrape our career sites, some of which we don't even know about. It's free exposure, so it's not a bad thing. And a lot of those are diversity sites, which is a great thing, right? So start there. Look into what's happening now that it's behind the scenes you may not even be aware of. Look into some sites that are free that you can take advantage of that might be a manual post. And definitely be sure that you take the extra 10 to when you are posting a rec to look into sites that are going to create a much more diverse candidate pool because you're gaining the attention of the audience. Also, what does your top 5 candidates look like for any role? Look for trends in your hiring and especially trends within specific hiring managers. At the end of the day, the hiring manager the company wants the best talent available for the role. And so we don't want to get away from that. But at the same time, are we doing things right on the front end to get those opportunities in front of a diverse audience and attracting a more diverse candidate pool? And so just take a couple of minutes, and I highly utilize, and something that I try and do is utilize those touch bases with hiring managers that are active in their hiring right now to revisit those top candidates and early in the process, middle of the process, towards the end. And are there trends in regards to the skill set that they kind of navigate towards? And do we feel like there could be a more diverse candidate pool when we do come to narrowing it down to our top 3 to 5 candidates? And finally, training. So important. Train your recruiters. I think that one's kind of a duh, Chad. Obviously the recruiters need to be trained on the compliance rules and regulations and how to avoid biases and what are our company specific guidelines. So train your recruiters, but train your hiring managers and train your interview teams, especially if you do have a process that involves a couple of peer interviews and those peer interviews typically are the same individuals. Train everyone. It's, something that doesn't have to take a lot of time, especially if you train early and train often. I have been a part of, the onboarding process. Might not be relevant for every role, but to take, 30 to 45 minutes with an onboarding class or some new hires, and just bring them up to speed on, we're a government contractor, and here are some rules and guidelines that we as a company have to abide by. Just making them aware not only makes them feel included, which is always a positive thing, but they might get involved with the interview process, and having them be aware of where you are as a company is really important. Offering continuous trainings, whether that's quarterly, monthly, biannually, anything that works for you and your bandwidth, to be a resource, be an advocate for all the compliance regulations that are out there, and then leverage team calls. It's something that I've done in the past. Every hiring manager that you work with as a recruiter has team calls, and whether it's every other month, once a quarter, whatever the case may be. I know time is limited. Ask that specific leader for the first 10 to 15 minutes, and jump on there and bring to their attention, that we are a government contractor and we do have rules and regulations that we need to abide by. And if you are a part of the interview process, making sure that you reach out to me, and here are some resources. So definitely making everyone aware of those guidelines, of those regulations, making them aware that we all are human and have implicit biases, and that there are things we can do to identify those, is going to create a very positive candidate experience and a very positive experience for your hiring managers, recruiting teams, and interview teams. So with that, I would love to turn the floor over to Izzy to discuss more about some rules and regulations.
Thanks, Chad. I'll do my best to keep the bar high. That was excellent content, super helpful. We're going to shift slightly and move into a little bit more narrow of an area of compliance. We'll be focusing on drug screening, background screening, and general inquiries into candidate salary and credit history. So recruiters who are also collecting data from candidates, those of you performing interviews, discussing background checks with candidates, et cetera, this will absolutely apply to you. I cannot stress enough how important screening compliance is going to be in 2019. Since 2011, lawsuits against employers that are based on background screening compliance has increased year over year. Class action lawsuits are super common in the screening landscape, and it's scary, but it's not unusual for us to see settlements in the 6 to 7 figure range for nationwide employers where there's been some allegation of screening laws being violated. So super important. And even on a single plaintiff basis, you're looking at around $30,000, $40,000, $50,000 for a settlement. So it can be financially crippling to run afoul of screening laws, especially for smaller businesses. And then we also have state and local laws that are sprouting up all over the place, and they're affecting how an employer can inquire into criminal history, how an employer can address a positive drug screen, even going as granular as saying, this is what you can post in a job ad. This is what you can't post in a job ad. So essentially, employers are being told now by state and local legislators what information they can consider in the hiring process, when they can consider it, and what action they can take. So that introduces a lot of complexity into employers' compliance frameworks, right? And it's easy to feel overwhelmed as a recruiter or a screener or an HR manager as a result of all of this. Next slide, please. For the rest of 2019, the folks who are reading the tea leaves feel that these are the 3 areas of compliance that are going to be very significant for employers. There will be a lot of litigation, settlement, and likely enforcement actions that are levied against businesses who don't stay on top of these requirements, especially those rules around medical marijuana use and employment. So I did want to take some time to address each of these today and share some tips on how to protect your business, while at the same time, and also as equally important, giving candidates that applicant experience that they're legally entitled to enjoy. We'll spend most of our time on the drug screening compliance, and then end with a little bit less information on credit and salary history and day-in-the-box development. Next slide. So what we're seeing right now in the medical marijuana landscape is new, and honestly, it's a little unexpected. We're used to zero-tolerance drug policies being the norm, especially for federal contract work, right? And this idea that marijuana is an illegal drug under federal law, and therefore employers can refuse to hire or they can terminate an employee if a drug screen shows the presence of marijuana. And that way of thinking, that concept of the employer's right to not accommodate medical marijuana is even captured under the Americans with Disabilities Act, or the ADA. The ADA expressly exempts from its protection the illegal use of drugs to treat a disability. So zero-tolerance policies, they were the norm, but they should not be anymore. 33 states and D.C. have now legalized medical marijuana, and 11 of those carve out protections for employees who use medical marijuana. Now, the states on this slide, I've put them here for your reference. This doesn't mean that you can never fire or reject an applicant who's a medical marijuana user in these states. What it does mean is that there are specific protections for these people built into the law, and it's going to require an employer to very carefully tailor the drug screening policies and make sure that they're being consistently administered. Next slide, please. I wanted to briefly point out, too, that the employee protections that exist are in states where you might not expect them to exist. So on the West Coast, generally, we see very little protection for medicinal marijuana users. Sure, you can go out and buy it at the corner shop, but when it comes to employment law, medical and recreational users are not protected, generally speaking, out west. These states on the left-hand side of the slide, they let an employer terminate or fail to hire because of a failed drug test. California, Colorado, Washington, Oregon, these are states where you'd think that employees would be protected, but that's not the case. You actually have to go out to the East Coast, where marijuana has been slower to be legalized, in order to find more employee protections. In the states on the right-hand side here, an employer, that they have to reasonably accommodate an employee's use of medical marijuana if they have a prescription, of course. But to be clear, they certainly don't have to accommodate it in the workplace, right? There's no law anywhere that says, as an employer, you have to let an employee smoke marijuana in the middle of their shift. Some of these states do specifically prohibit an employer from terminating based on a positive drug screen. So that's the protections that we're talking about here. The takeaway from this slide then is, if you're on the East Coast or if you're hiring on the East Coast, be very vigilant. Watch out. Court decisions there are really starting to favor employees who are bringing discrimination claims against businesses that fail to hire or terminate based on that positive drug screen. Next slide, please. I did want to just briefly give you some real-world examples of some state laws, just so you know what they look like, some medicinal marijuana laws and the protections. I won't read them, but the theme is this. In states that have medical marijuana laws, for the most part, employers cannot terminate or refuse to hire just based on the fact that there's a positive marijuana drug screen. Next slide, please. So there is definitely this patchwork of state laws here that restrict employers differently, right? We spoke about the difference between West and East Coast. But if you're a federal employer or you're working with federal contractors, you think it would be more simple, right? Well, unfortunately, that's not right. Recent federal cases tell us that federal laws like the ADA, like the Controlled Substances Act, or the CSA, and the Drug-Free Workplace Act, they don't conflict with state laws that protect medical marijuana users. Courts have found that employers can actually comply with all of those federal laws that I just mentioned, in addition to the state laws that are protecting medical marijuana users. They've essentially found that there's no legal need for an employer to fail to hire or to fire folks who are medical marijuana users. And so that means that both private and public employers have to look out and take note of the recent court decisions on these issues and the decisions that continue to come, because they will. So what do these cases tell us? Well, the short answer is a lot. They tell us a lot. And that's why this slide is a little dense. I wanted you to have some fodder for conversation with your legal teams. What we can learn from the group of unlucky employers who have been sued for discrimination by medical marijuana users who have been terminated or had conditional offers rescinded is this. Zero tolerance policies are not going to fly anymore. Let's talk first about a specific case, Nossinger versus SSC, the federal district court case in Connecticut. Real-world examples here. It just came out in 2018. This was the first case to determine that just because marijuana is an illegal drug federally, it does not bar an employment discrimination claim based on state law. So said in another way, employers in Connecticut can't point to federal law anymore and say, well, because it's illegal federally, we can have a zero tolerance policy. Specifically what happened in this case, the plaintiff accepted a job offer. It was made contingent on passing a drug screen. She was very open about having a medical marijuana card for her PTSD, and she took the drug screen, and no surprise, it comes back positive for marijuana. And then the employer rescinded the job offer based on the drug screen. So she sues under the state's medical marijuana law and has a non-discrimination provision in it. And the court found for her. And they said that SEC violated the state's medical marijuana law by rescinding the offer. And they even went so far as to say that the argument that the Drug-Free Workplace Act barred the company from hiring her. The court said no. The DFWA neither required drug testing nor prohibited employers from employing a medical marijuana user as long as that drug is used outside of the workplace. The court also said that, and this is super important because it's written into the opinion, the DFWA does not require a zero tolerance policy. So ultimately, the court said that the Connecticut statute protects the qualified user's use of medical marijuana outside of work hours. So there's a lot to learn from this case. If you're subject to the Drug-Free Workplace Act because you have federal contracts, zero tolerance policies, you probably need to go back and revisit them, especially if you're on the East Coast. In Rhode Island, Massachusetts, and Delaware, just this week, actually in Arizona, we're seeing more of this. So this is now a trend, and these cases all look similar. Candidates say, hey, employer, just so you know, I have a medical marijuana card. I will not bring it to work. I will not come to work high. They're very open. But then their offers are rescinded or they're fired after a positive drug screen. They then sue under the state's medical marijuana law. So in Arizona, just last week, this happened with Walmart. We had a current employee who'd been there for 8 years. She had a medical marijuana card, failed a drug screen. She claims she never brought it to work, was never impaired on the job. Under the state law, there is that patient protection. And there's actually verbiage in the law that says, look, you cannot be terminated for a positive drug screen unless the patient used, possessed, or was impaired by marijuana on the premises or during the hours of employment. Even though she failed her drug test, the judge said that Walmart could not prove that she was impaired at work. Or they could not demonstrate a good faith basis for believing she was impaired at work. So that's big because this case tells us if you fire an employee for a drug screen result, you better be able to provide a lot of evidence to show us why you think the candidate was under the influence at the workplace or during work hours. So that's where the change is happening. In the HR space, in the federal courts, we're really seeing this shift away from the thinking that a failed drug test automatically means adverse action. Medical marijuana users are now being protected, even when they fail drug screens at work. And it's important to note that the decisions I've referenced, they only apply to the jurisdiction of the court that heard the case. So just because the federal district court in Connecticut says something, that's not going to disrupt the law in California, for example. On the West Coast, we already said the landscape looks a little different. There is solid case law in California, and Oregon, New Mexico, and others that favors employers and the businesses there, and they can feel more comfortable taking adverse action based on drug screens. But personally, I believe that the East Coast jurisprudence is heading out west. It's just a matter of time before we see these types of protections and these types of lawsuits. So it might be that when you're crafting your drug screening policy, you do it through a broader nationwide lens, right? And you take into account these trends from sections of the country. Next slide, please. Before we move on to our next topic, I did want to leave you with a little roadmap for compliance. There is not, unfortunately, a one-size-fits-all solution to this changing drug landscape. But there are some things you can do to make sure that you're covering your bases and staying informed. First, talk to your legal counsel. Ask them what laws exist in your jurisdiction and how they should inform your drug screening policy. Second, get the C-level folks in a room and decide if you even want to screen for marijuana outside of suspicion-based testing. Some employers now are moving to 9-panel and 4-panel screens versus the 10 and 5, and they're essentially dropping marijuana from the list of drugs that are tested for. Also, create a drug screening policy. I can't say that enough. Some states even require that you have one in place and submit it to the labor office. But you need a policy, regardless, that sets out what testing you do, on whom, and when. And that's something you're definitely going to want to make sure you have reviewed by your compliance team or your legal team or even by outside counsel, just to make sure it's aligning with the current medical marijuana protections that are in place in your jurisdiction and the jurisdictions where you're sourcing folks. Have someone in your organization be a point of compliance, right? So say, hey, Johnny, we want you to follow the laws and make sure you update us when there's a new medical marijuana law that impacts us. You can always consult with counsel for more complex questions, but sometimes the biggest question comes from, or the biggest challenge rather, just comes from knowing what the current state of the law is. And finally, as the laws change, revisit your policy, make sure it's still compliant, and if you do have a zero-tolerance policy, maybe consider revisiting that, right? The cases that we've talked about show that they were the norm, but they can easily lead to litigation now. So just make sure you're talking with the right stakeholders at your company and that everyone's comfortable about what type of tolerance you have built into your policy. Okay, next slide. We'll shift gears a little bit and talk about salary and credit history bands. Chad already touched on the salary questions a bit. These are two areas of compliance that will also continue to gain momentum in 2019. As a matter of fact, you may have seen Atlanta just implemented a citywide salary ban. And I think we're going to start seeing some enforcement as well. Credit history bans, meaning running credit reports through a background check company. We see those sprouting up slowly but surely, but there's not quite as much intensity there as with the salary bans. It may seem as simple as just knowing where you can't ask these questions, and not just asking, right? But there can be a disconnect between your organization and its background screening company that leads to noncompliance. For salary history, an employment verification that's run through a screener may have a default question built into the verification that's related to the salary earned, and you might not even know it as the employer. You may not know that your employment verifications are asking for that information. So it's not unusual for an employer to order a verification for a candidate, an employment history verification, get the results back, and then find a previous salary listed there. And that can get you into trouble if it's on the report and you're in a jurisdiction that prohibits making the inquiry. So it's very important to clarify with your background screener whether they ask for that information, and if they do, talk to them about possibly suppressing that salary question when the candidate is in a particular location with a ban in effect. You can do everything right in-house as an employer. You can train your staff. You can know where you can ask, where you can't, only to have your screener end up putting that information on a background check. So you don't want that to happen. Please make sure you talk with your background check provider. They should be able to assure you that that salary information doesn't appear where you don't want it to appear. As for credit history, you'll want to be careful that you're only performing credit checks on folks when you're allowed to do so under state and local law. Very much like salary history, there's many bans in effect on the state and city levels. Where there are bans in place, there's usually a couple of carve-out exceptions for roles where candidates will be handling large sums of money or working in an executive capacity or with trade secrets. But it is important to check and only request that, only make the request into credit when you can do so compliantly. You'll want to pay special attention, too, to any consent forms that state laws may require. So in California and Vermont, for example, if you want to run a credit check on a candidate, you have to inform the candidate which exception under the credit history ban in that state allows you to perform the inquiry. And your screener can help you navigate that process, but it is something that you should be aware of. Okay, next slide, please. Okay, ban the box, our last topic for 2019. So since the 60s, we've seen this expansion of fair hiring laws. And most recently, this has come in the form of the ban the box movement. And that's a movement that's geared toward giving people with criminal records a better chance at employment. These laws do not typically, these laws typically require an employer to take that box off the application that says, have you ever been convicted of a crime, or do you have criminal history that we should know about? And the goal there, by taking that box off, the goal is that you're going to give folks a better chance of finding a job and thereby reduce the recidivism rate in our population, which is pretty high. So over 180 jurisdictions, including 33 states, they've passed the ban the box law. About a dozen of those currently impose restrictions on private employers. So don't think that because you're a privately owned small business that you don't have to worry about this trend, because you do. Next slide, please. It's important to understand just how different ban the box laws are, though. They vary by state, they vary by city. Some legislation will only restrict public employers, some will restrict public and private, or just private. Some of the laws will merely prohibit an employer from asking about criminal history on the job application. Other locations will go further, and they'll require an employer wait until a conditional offer is made before they can make that inquiry. Further yet, some locations will require employers to send specific notices or notify candidates about specific reasons on what in their criminal record history led to adverse action. So let's talk for a minute about what kinds of things you're going to be seeing in these ban the box laws. All of them, every single one of them, requires that inquiry into criminal history be taken off the job application. Okay, so that is a consistency across any ban the box law, hence the name ban the box, right? When you can ask the question and when you can run the check is going to vary by jurisdiction, but it's generally either after a conditional offer or after an initial interview. Aside from that delayed inquiry, the requirements it's a mixed bag, but they will fall into a few buckets. The first one, the administrative requirement bucket. You might be required to post certain notices in your office, keep certain documents for a certain period of time, send annual reports to an enforcement agency, include specific language in job postings even. Secondly, consideration of records. Some ban the box laws will limit what kinds of records you can consider when you're making your decision. You might be restricted to 7 years of history. You might be restricted to only convictions and pending cases. The assessment bucket. A lot of these laws are now requiring employers to perform individualized assessments, or really more like a back and forth dialogue, as part of the adverse action process. So under EEOC guidance, these assessments are already recommended, but the ban the box laws are taking it further and they're making it a legal requirement now. And then finally, the adverse action notice bucket. Some laws will require that certain information be provided in an adverse action notice, such as what specific record led to the denial, or information about how a candidate can file an appeal with the employer. Those are the things you're going to see in ban the box laws. Next slide, please. So what do? How do you avoid a ban the box violation or an enforcement action? Well, you can follow some best practices. First, remove the prior conviction question from your application if at all possible. Even if you're not currently in a ban the box jurisdiction, you may be working with candidates who are. And ban the box laws they're coming out so quickly, it just makes sense to be proactive. Secondly, if you do want to keep the inquiry on your application and you're not in a ban the box jurisdiction, consider leaving some room on the form for candidates to provide context around any records that they do have. That also looks good to the EEOC under Title VII. Stay up to date on ban the box laws so that you know when you need to modify your processes. You can get news alerts via your favorite search engine. You can look to your trade associations. You can look to SHRM. They have great resources. NELP.org, the National Employment Law Project, they have a wonderful set of resources for ban the box. And finally, work with a screener that understands it and actively guides you through these requirements. A reputable screener is going to understand the complexities of all the jurisdiction's laws, and they're going to be able to help you craft a solution that meets your needs.
All righty. Thank you so much, Chad and Izzy, for your presentations. We're now going to open it up for Q&A. And as I mentioned at the top of the call, feel free to chat those in at the bottom right-hand corner of the Ready Talk panel. I see a bunch of questions that have already come in, but please continue to chat them in, and we will try to get through as many questions as we can. So I see a couple here. I'll start with first. I think this one is directed to Izzy specifically. It says, you mentioned that ban-the-box laws sometimes create requirements related to job postings and other pre-screening steps. Could you expand more on those?
Yeah, sure. Well, now remember, so these requirements, they vary so much from one city or one state to the other. But I can give you some examples where these requirements exist. So in San Francisco, for example, the ban-the-box law there requires that all employers with at least 5 employees who have somebody working in San Francisco put up a specific fair chance notice in every job site and at every workplace. Now, the Office of Labor Standards and Enforcement, the OLSE, is the enforcement body there. They've created this notice. It's not something you have to come up with, but you do have to print it out from their website or get it from their office and make sure that it's posted very conspicuously where all candidates coming in and all current employees can see it. You also have to include in all job advertisements that people with arrested conviction records will be considered in accordance with the Fair Chance Ordinance there. And when I say Fair Chance Ordinance, that's the ban-the-box law. That's what they call it there. In New York City, we see something similar. You're prohibited from mentioning in job ads and solicitations that background checks or criminal inquiries will be made. And in LA, another example, there are notice and posting requirements there too. Employers have to state in their job advertisements in LA that they will consider qualified applicants with criminal histories. And they also have to post the Fair Chance Law notice at their workplace as well. It's a similar law to San Francisco's, but it is important for us all to understand that these ban-the-box laws are very broad, and they cover a lot of steps in the hiring process from recruitment all the way to onboarding. And so the requirement that you include that specific language in a job ad or in a solicitation, whether it's on a job board or in a newspaper, I don't know if people even do that anymore, but wherever the job ad is listed, it has to contain certain language in certain jurisdictions, and it has to avoid certain language in others.
Great. Thank you, Izzy. And I have one more question here for you. It says, are company staff federal contractors into jobs that are regulated by the Drug-Free Workplace Act, a federal law? Are we safe to continue using zero-tolerance drug screening policies since the DFWA requires it?
Oh, yeah. So that goes back to a couple of the cases that we talked about. It is tricky. It is admittedly very tricky because, some courts like Nossinger have said, like in the Nossinger case, that the DFWA actually doesn't require zero-tolerance policies. There's that shift in thinking from what we, assumed that the DFWA did require. So in the states where we have a ruling like that, where it's not required, then a zero-tolerance policy probably isn't compliant. And you're going to need to make sure you're affording protection under a state medical marijuana law if there's one present. Out west, it could be slightly different, right, where you don't have the same case law that has made that decision on the Drug-Free Workplace Act not requiring a zero-tolerance policy. So out west, I think you'd be a little safer continuing to use that policy. East would be a mistake to assume that you can continue doing that without consulting counsel. And I do need to just make this quick disclaimer. None of this is legal advice, right? This is just business advice. And make sure that you consult your own attorneys and your in-house legal teams before making any sort of changes to your policies. But yeah, long story short, it is tricky. I would say out east, on the east, I would highly recommend not having a zero-tolerance policy. Out west, you're probably a little safer, but it's still worth chatting with your lawyer about.
Great. Thank you, Izzy. And I have a couple more questions. I see a lot of people chatting in. I see two. I think we have time for a couple more questions. The first one, I think this is more of a Chad question, is do you have any recommendations on proper training materials or training methods as it relates to interviewing and staying compliant?
Absolutely, yeah, that's a great question. So, one thing that I have implemented in the past, and I definitely recommend is, this takes a little bit of time, but thinking long term and making sure that you are staying compliant, I highly recommend it. So, have the regulations and guidelines in front of you. And while those are in front of you so that you can consistently reference those, create competency guides specific to different roles or similar roles within your company. And what this does is allows you to stay compliant, creates a set of questions that are relevant for the role, and gives your interview teams and gives you as the recruiter some not only a resource, but your own guidelines to go by. So this way you are staying compliant, staying within regulations, asking pertinent questions as it relates to skills, experience for the job they're being considered, and then also creates consistency if you are sharing these competency guides with interview teams and with hiring managers. That's going to, again, create a positive experience for the candidate, also keep you within those OFCCP guidelines.
Great, thank you, Chad. And one more question is, what if a candidate voluntarily shares their current compensation/salary during a screen or an interview?
If that happens, you definitely have an upper hand as the recruiter. So recommendation there is, obviously to the question, it's voluntarily shared. And so let them share. I think as a recruiter, we've all learned that it's a bit of a trust with candidates in regards to, talking about compensation and what they're looking for. And if they voluntarily say, I'm making X amount per year now, take it with a grain of salt. Don't document it. What you want to document on the candidate profile is a salary range that you have discussed with the candidate that they would be looking for in a new opportunity. So if they do share it with you, kudos to you for having a bit of insight into where they currently are. But as far as documentation and where you need to steer the conversation is towards the range they're looking for in their next opportunity versus where they currently are today.
Thank you, Chad. And I think, unfortunately, that's all the time that we have for today. I just wanted to say thank you for joining our webinar. Thank you to our speakers, Izzy and Chad. I know there were some questions that we weren't able to get to, so if we weren't able to get to your question, someone will be reaching out to you either tomorrow or early next week. And again, we will be sending out the slides as well as the recording of the webinar sometime tomorrow. So please be on the lookout for that, as well as the SHRM credits will be sent out tomorrow as well. So thank you again, everyone, for attending, and have a great day.